No, thank you to Jerry, to Amac for having me here today. I enjoy getting the opportunity to speak across the state. I was telling Jerry before the show, I was a guest on a radio show yesterday called The Consumer Quarterback. That's hosted by my good buddy Brandon Rhymes. He's done a consumer advocacy show for about 9 years now out of Tampa. And oddly enough, the topic yesterday was Florida homestead law. So it was a great way to sort of warm up for today's presentation. But a little bit about me. Jerry did a great job with that introduction, but a little bit more. I am married to my beautiful wife, Christy. Next month, we will celebrate 19 years together. And we have one son, William Patrick, 16 years old. He has all the solutions to all the world's problems. Just ask him to be 16 again. No, he's a great young man, has a passion for deep sea fishing. That is what he wants to go into. He is dripping with certifications of varying varieties and just waiting for the day that he turns 18 and he can get under the insurance policies for a lot of these mega fishing yachts. I am the author of a couple of books on estate planning, and I do host my weekly radio show. That's called the Attorney Patrick Smith Show. We've grown from 5 stations up to 14 that now carry the show every week, and it's Saturday mornings at 8 a.m. And for those of you who were groaning in your head when I said 8 a.m., there is a replay Sundays at 5 p.m. if you're not an early morning person. Some of the stations are listed on the placards you have. There are 14, and several of them reach this area. I believe it's AM 760 is the AM signal for the Lake County area. There's also 102.5 The Bone and 104.3 FM. Those all cover this particular area. That's enough about me. So what am I going to talk about today? I'm going to talk about Florida homestead in as much as we can in 25 minutes. And then I'll try to leave as much time as possible for Q&A to make sure that we get to your questions, which is really what I'm looking forward to, because that is where I get to learn. I get to learn what's on the minds of the citizens of the great state of Florida through your questions. So that being said, let's jump right into it. When I said Florida homestead, how many of you instantly thought about your ad valorem property tax exemption you get every year? For those of you watching online, people are raising their hands right now. How many of you can name any other aspect to Florida homestead law outside of that? No one. And that's very common. A lot of people start and stop their analysis of Florida homestead law with Florida Statute 196. That is our ad valorem property tax provision, which says the first $50,000 of the value of your home is free from any taxation. That's a critical thing to know. The deadline to apply for that is March 1st. You want to check with your county exemptions officer. Typically, we recommend just speak with the head exemptions officer in your county. What items do I need to bring in to apply for my homestead exemption? Usually it's a copy of the deed. It'll be some sort of proof that you live there, like a utility bill, maybe a copy of your voter registration card. They will tell you what they want to see, and the deadline's March 1st. So that is a great feature to Florida homestead law, and especially with the Save Our Homes provision where the taxes can't go up more than a certain percentage. So these are great protective measures to protect people's homes from a tax perspective. However, that is only about 5% of Florida homestead law. The other 95% gets missed all the time, and it gets missed by a lot of attorneys from other states who come to Florida as non-licensed Florida attorneys trying to advise out-of-state clients on Florida homestead. And it gets missed because they scour our statutes. And they say, I keep hearing about this homestead law, but I don't see anything in the statute regarding Florida homestead other than the property taxes. And that's because this particular provision lives not in our statutes, but in our highest body of law in the state of Florida, our state constitution, specifically Article 10, Section 4. This particular provision lays out the number 2 most popular feature of Florida homestead law, which is your creditor protection. Your Florida homestead property is exempt from any and all creditor claims under Florida Statute, or Florida Constitution, Article 10, Section 4. Save two exemptions. There are two exceptions to this rule. One, we've already talked about it, your property taxes. If you don't pay your property taxes, the county can lien your property. The other is called a mechanic's lien. What's the example of that? You hire someone to come in and put a pool in the property, and then you don't pay that person the fee that they have justifiably earned, they can file a mechanic's lien against your property. Other than those two exceptions, your home is creditor protected. Now, that's a big protection. What's the cap on it? Well, there is a cap, but it's not an economic cap. So your home can be worth $500,000, it can be worth $200,000, it can be worth $10 million. There's no economic cap on that creditor protection. Where is the cap? The cap is in the geography, and it's in the geography in two different ways. The geography first based on the size of the lot, and the geography based on the location of the lot. So first of all, within the city limits, the cap is 1/2 acre. So that you're limited within the city limits up to 1/2 acre of property. Outside of the city limits, anybody want to guess? 160 acres. And it doesn't really make a lot of sense until you consider when the state of Florida Constitution was drafted. Go back to 1800s Florida. Think about the nature of our economy. What was the primary industry? Agriculture. It's an agrarian economy, even more so than it is today. And if we know one thing, the legislature back then probably comprised of a lot of agrarians, a lot of farmers. And what's one thing we know about Congress and most legislatures? Who do they protect first? Themselves, that's right. I think that's a criticism throughout the country. And it's one of those things that's truth in reality. So 160 acres, approximately the average size of a farm back during that time period, it still applies to this day. So those are the caps. Notice there's no value, though. It's a geography that's a cap. So if you have people like physicians who are very concerned about being sued for malpractice or something, pouring millions of dollars into a homestead property, you now understand why. There is a creditor protection aspect to this. So the next positive feature of Florida homestead law, your creditor protection. Now, there's two sides to this conversation. It's the same public policy. We think it's a good idea you have a place to stay, so we're going to protect it from your creditors. But the other side of that public policy coin is we expect you to protect it for certain people that should be important to your life, namely minor children and spouses. Let's talk about those sort of in an increasing relevancy. Minor children, looking at the room, I'm guessing is probably less of an issue for this crowd. This is probably more of an issue for your kids. But if you have a minor child, the state constitution does restrict the devise or the bequest of your homestead property. This is one of those restrictions where we say, hey, we're going to protect your home from creditors, but we're going to require you to protect it for your minor children. Now, for most people, the exception here hollows out the rule. If you are a married couple owning the property together with a minor child, it is a moot point. Because if it's jointly held marital property between husband and wife, this restriction does not apply. The couple together is free to bequest between each other because it's jointly held property between husband and wife. But let's change the facts. What if one spouse has passed? Now it's a single widow or widower who has a minor child. Now we have devised restricted property. Or the case that I had, where a family member passed away and their child, their minor child, now was passing to the grandparent in their 70s as the child and being formally adopted by that grandparent. We now have a grandparent who has a minor child. Their homestead, which hadn't been restricted in years, now suddenly devised restricted, and we had to accommodate for that in their estate plan. So there are devised restrictions on Florida homestead property with regard to minor children. The second prong, which is probably more applicable to this audience is with regard to spouses. And there's two types of restrictions here. There is the spousal restriction on alienation or transfer of the property, and then there's the spousal restriction on devise. Let's talk about them in that order. The state constitution, Article 10, Section 4, subsection C, says it in the affirmative. It says you may alienate or you may transfer homestead with spousal joinder. But it's the converse that really shows us the rule. You may not alienate or you may not transfer the property without spousal joinder. What does that mean? Did you ever wonder why any of you go to a closing and the property was just in one spouse's name? They're the only name on the deed, and they still required the other spouse to sign. This is why. The state constitution says you can't transfer that homestead property without both spouses signing off, regardless of whose name appears on the deed. Tons of deeds in the public record fail to meet this requirement. I'll give you an example. Case where you had a widow and a widower who met at a bereavement group. This is a very common story, especially in the villages. After they marry, the husband decides to do his estate plan. He creates a trust, and he transfers his homestead property to his trust. But his spouse did not join on that deed. That is what we call an invalid conveyance to the trust. The spousal joinder is required to transfer the property. Number two is with regard to the spousal rights to inherit. We can also demonstrate this with our same example we just gave. So the husband who had his wife now join on the deed. Let's hypothetically presume they've corrected that error. The deed is signed by the husband as the owner of record, joined by the spouse pursuant to the constitutional requirements. The home is now in his trust. In his trust, he says, I leave it 50-50 to my two boys. Is that what happens? No, not necessarily, not without some additional steps. Because the surviving spouse has the rights to inherit parts of that property. What are those spousal rights? The default provision for the spouse, if the spouse does nothing at all after the death of the husband, the spouse will get the right to live in that home for the rest of their life. This used to be the only option. So that means they're the life tenant of the home, and our Principal and Income Act will lay out who's responsible for which expenses. So typically, the ordinary upkeep expenses are the responsibility of the life tenant. The remaindermen here, the children, are responsible for any capital improvements. Mortgage payments are a really good example. When you have a mortgage payment on a property and the spouse has a life estate, the children have the remainder interest. They get it when the surviving spouse passes. The mortgage payment is usually broken up into two pieces. The interest portion of the payment covered by the life tenant, and the principal portion covered by the remaindermen. So that being the case, you have a situation where the surviving spouse now has to split these expenses with the remaindermen. As of 2010, there's a new option, though. The surviving spouse within 6 months of the date of death, I'm going to repeat that because that's a critical deadline. A lot of people have a misunderstanding, and they think, well, it's 6 months from the notice of the estate administration beginning. It's not. It's a hard deadline from the spouse's date of death. If you miss it, there's no extension. But within that 6 months, the surviving spouse has the option to say, I'm going to elect to take a 1/2 tenant in common election in that property. Let me demonstrate the reach of these constitutional provisions. This was a trust set up validly by a late father for the benefit of his two children. The spouse's name is nowhere on the deed as an owner. The spouse is not mentioned at all as a beneficiary in the trust. And yet the spouse has the option of walking away with the right to live there for the rest of her life, or to take half the value away from those children, all because of Florida homestead law under the state constitution. How do couples adequately address these constitutional rights? Most commonly, what they do is something called a prenuptial or a postnuptial agreement. You'll see prenuptial and postnuptial agreements are no longer sort of pre-divorce contests like they used to be in the 80s. I mean, you still see those. The wife shall maintain a certain weight or less. The husband shall maintain a certain income or more. I'm not kidding. So they can be as specific as you want. But these nuptial agreements nowadays are commonly used as extension of estate planning tools, where under 732-702, our statute on spousal rights, says that you have to show a knowing waiver. Meaning you have to show in the document that the spouses knew they had the right to this homestead property, and they specifically waived that right to inherit. That is the way to set aside the constitutional interference with your estate plan. But if unaddressed, be aware that these issues will linger. And lots of people all the time say, well, it's not written that way in the trust. It matters not. The Constitution will override these particular provisions. With that, I will hush and I will take questions. Any questions? Yes, sir, in the back.
You said that, for example, if I pass away and my wife is, on the deed.
Yes, sir.
And I have a will that says my daughter gets, my wife gets everything, and then my daughter, if my wife passes away, my daughter gets whatever's left. Does that, are you saying that while my wife is alive, she lives in the house and my daughter has to pay something?
No, so the example that I gave was a second marriage.
Oh, okay.
And in that scenario, Dad left the property to his two boys from his first marriage and then remarried.
Okay.
Your scenario sounds different. I'm going to take a stab in the dark. It's a first marriage.
Yeah.
Only child.
Yes.
And you're leaving everything to each other.
Yes.
And then to the child.
Yes.
No issues.
No issues. Okay. Because tomorrow I'm talking to another lawyer to do a trust.
Mhm.
So when you said something about trust and the Constitution overrides the trust, that I got like, whoa, what's going on?
No, but I can change the facts to
Okay.
make it applicable. So let's say your spouse dies before you.
Okay.
You find some pretty young thing.
I will.
Could be a long car ride home. So if that happens, though, and you have a situation where you marry the new pretty young thing, and your will still says, well, if my wife has predeceased me, my first wife, and I leave it to my daughter, now your daughter has this homestead problem because she thinks under the will she gets it all. But here's pretty young thing marching in saying, I'll take my life estate or my half value.
Okay.
So that's where the nuptial agreement would be critical. And I tell clients this all the time. I see clients who meet with spouses, they lost their spouse of 50, 60, 70 years sometimes. I mean, they are apoplectic when they come in, and God bless them. I pray for them every day. I've only been married about 19 years, and I have no idea how I would move forward without my wife.
Right.
I do not know how people do it after that long, 5 decades plus with a person. But I tell my clients, I say, look, at the risk of sounding gauche, when I'm talking with them at these appointments after the death of the spouse, I say, I have to plant this seed. If you should ever consider remarrying, make certain that you consider a prenuptial agreement. So clients come in to do our standard trust package, which is $695, and that covers trust, pour-over wills, power of attorneys, healthcare surrogates, living wills, the whole 9 yards, including the deed for the homestead. It's that follow-up, though, after the death of the first spouse, though, where we can protect the estate by saying, we're going to have this nuptial agreement. And I have clients tell me all the time, oh, never going to happen. And then 6 months later, guess who's calling?
Right.
I'll never forget this one. Client who passed away, the husband came in, I gave him that speech about the nuptial agreement, never going to happen. 6 months later, he called me. You were right, getting married. And I said, oh yeah, I said, congratulations. I said, that's terrific. He goes, no, you're going to be ashamed of me. I said, I am. I said, why is that? He goes, it's a younger woman. And I said, I'm your lawyer, not your judge. I'm not going to be ashamed of you. This gentleman's 86, by the way. I said, but I am curious now, how young are we talking? He goes, well, I don't know. I said, oh, just let me guess. I said, is she in her 40s? He goes, no. I said, 30s? He goes, no. I said, is she in her 20s? He goes, oh, Lord, no, Patrick, one of those would kill me. She was 79. And he was so guilty about marrying a younger woman. Never forget it. So, any other questions? There were other questions over here? No? Yes, ma'am.
My question before, did you clarify that was a second marriage in your example, and you clarified that. So we went into the county office, got our driver's licenses, car registration, voting, and on our way out, we were going to ask a question about Homestead, and she said, oh, I can sign you up. So we, because you mentioned a deed, but we have this form that said we've filled out and signed for the Homestead. Is that all we have to do?
Right, you already have the deed in place, because the deed is the document that shows you have ownership. So when you were there at the office, at the county office, they already had your records pulled up. They were looking at the deed, so they knew they didn't need it, because they were staring right at it.
You were just talking about the ownership deed.
Right.
Okay.
There's no subsequent deed, just the deed showing that you validly took ownership of the property. That's under what we call the present possessory interest requirement under Florida Statute 196.
Okay. Thank you.
Any other question? Yes, ma'am. Ann?
When the husband and wife both pass away and the house is inherited by the child, do they still have that homestead done?
Ooh, good question. So the question was, husband and wife both pass, goes to child. Does the child get the homestead protection? Yes, is the general answer. And it's under Florida statute, or I'm sorry, state constitutional provision, Article 10, Section 4, also, and I think it's subsection B. It's called the annulment clause. So it's a legal fiction. It basically says that homestead, the moment you enter eternity, there's no lag in ownership. It immediately inures to that lineal descendant, the child in your hypothetical land. So yes, they would receive creditor protection. So in other words, if you die owing $2 million in medical bills, and we have homestead going to that child, bulletproof. It's inured. Now, there's some breadth of that, and there's a way to narrow it. Let me talk about how broad that is, first of all. There's a famous case called Snyder V Davis, and this was the case where the Florida State Supreme Court was deciding between two different theories on lineal descendants for homestead property. Were they going to go with the literal lineal descendant, meaning the next in line, in your hypothetical, the child? Or were they going to go with any actual lineal descendant? Maybe not the next one, but it's someone within that class. So the actual beneficiary there in Snyder v. Davis, the child was disinherited, and it was left to the stepchild. So the question was, before the Supreme Court, since this isn't the actual lineal descendant, it's just a lineal descendant, does it still get the protection? And the court said, in keeping with the long history of broad application of homestead protection, in other words, Florida likes protecting your home, we're going to allow it to apply to any possible lineal descendant. So the stepchild was allowed to take, with creditor protection, free of creditor claims, even though they weren't the actual next in line lineal descendant. Does that make sense? There are two ways to truncate this protection. You will see two line of cases, In re Cutler and Price. So In re Cutler and In re Price, two different estates. I believe it was the Price estate where the will said the home must be sold, and then the distribution to the child. The court said that is not a bequest of homestead property, that is a bequest of cash, because it is instructed to be sold. So attorney said, that's a bad idea. We're not going to say must be sold, because why? We lose our creditor protection. Does that mean the child can't sell the home? No. It means you can't direct that it must be sold. So attorneys started stepping back from that and would say things like, well, it may be sold, it could be sold if you need. They just didn't say must. And then here comes Cutler. In the Cutler case, they said, if you need to sell the house to satisfy debts, that's okay, you can. And the court said same thing. The reference to the sale, we're treating it as cash. The creditors can come after it. So now what do attorneys do? We don't say anything about selling the homestead property because it risks that creditor protection and that inurement to the lineal descendant under Snyder V Davis. Did that answer your question, Ann? That was a really long answer to a very short question. I appreciate it. Yes, sir, you had a question? I skipped over you. I'm so sorry.
Hypothetical, somebody lives out of state, and you were mentioning you sued for malpractice, and then they move down, buy a house in Florida. What date does that protection actually begin? Because if somebody's in the process of being sued, can they essentially park money and avoid a judgment on that money after the lawsuit is, after the lawsuit process has started?
Yeah, I think it's going to come down to being intensely fact-specific. And I say that to say this for two reasons. One, Florida residency is an intent-based test. If you intend to be a Florida resident, congratulations, you are. You don't actually have to own dirt here to be a Florida resident. And I tell people all the time, I say, you ever wonder why Tiger Woods, President Trump, LeBron James, why they were all Florida residents? It's for the tax breaks. We have no income tax, we have great asset protection tax, we have homestead protection. So I think if you intend to be a Florida resident, you're fine. But I think the facts and circumstances should bear that out. You should have a driver's license here, things like that. I think if you're going to do one thing to make it outcome determinative that I have declared myself a Florida resident, it's called a declaration of domicile. You can do it on your own, probably the only time you'll hear an attorney say you can do this on your own. But you can prepare the instrument saying, as of these dates, I was a resident of Wisconsin, New York, Minnesota, Michigan, wherever. But as of this date, forward, I am a Florida resident. File it with the county seat. That's your declaration of domicile. Even as a Florida resident, you're now subject to Florida Statute 222. That is our statute on creditor protections. And under 222, any maneuvering done as an attempt to defraud a creditor can be set aside. So if you start moving things around in suspicious ways, you are subject to having those transactions set aside. But this is a great example that's not suspicious. Someone has a $2 million home with a $700,000 mortgage still outstanding. They get sued. They cash out something to pay off the mortgage. That's not illegitimate. They were paying off a debt that was outstanding. But if they started divorcing their spouse and giving their spouse everything in the divorce, well, that's going to raise some red flags. So you have to kind of look at the facts and circumstances surrounding that situation kind of case by case, if that makes sense. Does that answer your question? Okay. Yes, ma'am, in the back. Unmarried couples? You mean those who are living in sin? No, so I'm teasing. I'm a lawyer, not a judge. So at the end of the day, Florida has no common law marriage. I mean, that came up under our DOMA. Lawyers love acronyms. DOMA stands for Defense of Marriage Act. And constitutional scholars have debated for years whether or not DOMA is going to stand up in light of same-sex marriage and that now being legitimized here in Florida. But the constitutional scholars, liberal, conservative alike, kind of seem to agree that the Defense of Marriage Act provision outlawing common law marriage will survive the legalization of same-sex marriage. And here's why. Defense of Marriage Act restrictions on common law marriage applies exactly the same to heterosexual couples as it does to homosexual couples. There's no difference there, so there's no discrimination. So Florida does not permit common law marriage, and I don't think that's going to change.
To the other person? Does the homestead automatically go over to that other person?
It depends. If the property is jointly held,
Okay.
I think then you have a right of survivorship situation. So yes.
Okay.
I don't think you have annulment. I think it's a shade back from a Snyder V Davis case because we have not a spouse and we have not a lineal descendant. So there is some vulnerability there, although it's difficult. Because that right of survivorship, the transfer so quick for a creditor to act would be extremely difficult.
Okay.
So I think it would be an uphill battle for them. Florida makes it difficult for creditors. They're not a very creditor-friendly state.
If you put it in the will stating that that person has the right to the house, even though one person is on the deed.
Mhm.
In my case, because I'm a widow, I get a little bonus, cut off my taxes. But if the other person, if I should pass, that other person is going to be, won't get the homestead?
So let me understand, make sure I understand the facts.
Yeah.
So your name is or is not on this deed?
Is the only one on the deed.
Your name is the only one on the deed, and your will says, I leave the property to this significant other.
Yeah,
And your question is, does that get homestead protection?
correct.
No,
Really?
no, because they're not a lineal descendant,
Okay.
and they're not a spouse.
Oh, okay.
So it's creditor exposed.
Oh,
And I've seen that case
surprise.
where clients come in and they say, well, this was my late husband. And they left, and under In re Finch, that's fine. You can leave the house entirely to the spouse.
Mhm.
There's no issues with that. But when you have that situation where the client then, 6 months into the process, says to you, well, we weren't really married. I say, what do you mean you weren't really married? Well, we were married in the eyes of God. All right, well, were you married in the eyes of the state of Florida or not? So people are starting to do that, so it's, it causes us to ask at that initial appointment, may we see the marriage license? And that's just good prudence, I think, because at the end of the day, people do consider themselves married and they're not legally married. Florida allows for constitutional homestead protection for spouses, legal spouses, and lineal descendants. So, yes, ma'am, the front row here.
My sister and I own property together. Now, recently, I sold my property in Virginia, and now I am a resident of Florida. My sister is still a resident of New York. So at this point, I want to homestead so that I can get the break on the taxes. So how do I go about homesteading?
So you can homestead your undivided interest in the property. If sister's a New York resident with her New York property, she cannot homestead her portion of the property because you can't have two homesteads. So if you want to homestead 100% of the property, you're going to have to get sister's name off the deed. So, and the hypothetical there is be careful with co-owning property with people who aren't spouses. Because now if sister, God forbids, in a car accident today, guess whose property they can come after?
Well, we already have a trust.
Yeah, the trust doesn't help with the liability exposure necessarily.
Well, the property is, we own the property. There's no mortgage on it.
But you own it in both names.
Yes.
So if your sister's part of a lawsuit, she hurts someone in a car accident and gets sued, they can come after the assets in her name potentially, like the property you're referencing. Or if she goes through a divorce or a bankruptcy, her name is on your asset, so be aware of that. Plus, unless she's paying for half, there can be gift taxes. Be aware of that as well.
Well, we did go to an attorney, and we have the right of survivorship, and also if something should happen to me, she would still be able to be in the home, and if something should happen to her, it's left to our 4 children.
And that's fine, but it doesn't address the liability issue in existence now and the potential gift taxes. So if you and sister each paid for half the house, not a concern about the gift taxes, but liability is a concern. If you bought the house and then added sister's name to the deed, I'm very concerned about the gift taxes. So, did that answer your question? The short answer is, since there's a trust involved, I would have to review the trust. We do a complimentary consultation. All you for attending today, if you want to sit down with us, free of charge, you've got the office number. You can call the office and they'll set you up for a complimentary consultation.
I would only be able to homestead half of what the property is.
Whatever your ownership interest is, because you don't own the other half. How can you homestead something you don't own?
So as far as taxes go, I would probably not get the 100% tax advantage.
I don't think so.
I'd get 50%.
Based on what you're telling me, yes. I haven't seen your particular deed. You may own more than 50% or less, but assuming it's 50-50, yes. So I've got time for one more question. Yes, sir.
We're from Indiana, and we have our deed for the house recorded as joint tenants with rights of survivorship and transfer on death to the kids, I think, something pretty close to that. And so we came here and buy this second home, and it says, oh, our equivalent in Florida, that's a ladybird deed. And basically, they put the same terminology on there, you know, me and my wife, joint tenants with rights of survivorship, and it says a ladybird deed with our kids as survivors.
Yeah,
Was that an appropriate technique?
It depends. It's very rare for me to use a ladybird, and this is a perfect question to end on. So the ladybird deed's a leftover vestige from the 70s. 1975, let's turn back the clock. The estate tax exemption that's $12 million today, over $12 million actually, was $176,000. So in 1975, if I have a $500,000 house, I've already got an estate tax problem, let alone a probate problem. So estate taxes, 15 to 40%, they're big taxes, and we want to avoid those. Well, how do I avoid it? Well, I have to get the home out of my name before I die, right? Well, if I just sign the house over to the kids, have I avoided taxes? Well, I've avoided the estate tax, but I've run headlong into what? The gift tax, which track the estate tax rates, but I have to pay it now. I've accelerated my tax, so I pay it earlier. That's not a good idea. So attorneys create what they do, solutions like ladybird deeds, where the deed is broken into two pieces divided across the plane of time. You keep the right to live in that house the rest of your life. And then you give your children what we call a vested remainder interest. Now, that life estate that you kept, if you're young, in your 60s or 70s, that has value under Table 7520 of the Internal Revenue Code. You look up the value of the property, life expectancy of the donor, match it up. There's your life estate value. Let's say hypothetically, $500,000 home, 60-year-old parent doing a ladybird deed. We now have a life estate worth $300,000. That means we have to pay taxes, but only on $200,000, not on the full $500,000, plus the gain, the increase in the property after this, not part of our problem. That's good planning. Matter of fact, some would say it was too good, because it got the attention of Congress. Congress noticed their coffers were going like this because of these ladybird deeds. And a lot of people thought the Congress was just going to say you couldn't do them, but they didn't. Instead, they did what Congress does best, especially the IRS. They set a bear trap. They said, ladybird deeds, huh? You like doing those? Keep doing them. We dare you. But if that person that gets the remainder interest is what we call an applicable family member, children are certainly included in that category, very broad interpretation there. Cousins are not, by the way, but for most people, this hollows out the rule. Children are covered. If that vested remainder interest holder is an applicable family member, your life estate, that $300,000 you kept back, is deemed to be valueless. It's zero. So we're back to square one. It's like you just signed the property over to the kids. And it's a full gift. So we have gift taxes to address, and either have to pay gift taxes or file a 709 and allocate unified credits to it. And if you didn't do it, you say, well, I haven't heard anything from the IRS. There's no statute of limitations for gift taxes that were never filed, or return that was never filed. And there is something called penalties and interest. I also don't like ladybirds for a couple other reasons. One, they don't do anything until you die. So if you're prolonged incompetent, like because of dementia or a coma, the kids are frozen because it's a life estate to you. As long as you're alive, it sits. And number three, it doesn't guarantee that it avoids probate. How? Sometimes the children die first. Now we have a deceased child with a vested remainder interest in our house. We're probating our own home because our child died owning it. And here's that, another point. The child's will may say everything to my spouse. And you didn't want it to go to daughter or son-in-law. You wanted it to go to the grandchildren if your child passed. But it doesn't matter. Their will drive that. Does that answer your question? So I think the ladybird can work, but I think there are more efficient strategies. Usually a simple trust will be far more optimal. But again, it's estate to estate, and that's why we do the complimentary consultation. All right?
Thank you.
So if you had more questions, you have my contact number. You can all call and set up that complimentary consultation. I want to thank Jerry and Amac again for having me. If you just thought of a question, you can always tune into the show Saturday mornings, 8 a.m., call in with a question, or if you just want to call me at the office during the week, you're always welcome to do that. We never charge for questions at my offices, only for the answers. Thank you guys so much.
As you can see, he's a very gifted presenter and a very colorful kind of guy, and we enjoy working with him. Let me just make one comment about today's session. We have recorded it. It will be on our website probably next week sometime. I have to edit it and get it prepared to load on our website. Our website is amacfoundation.org, and if you go to the videos page, you'll find it on the videos page. So sometime next week it'll be up. I know when I sit through these kind of things, afterwards I wonder exactly what did he say, and so I like to rewatch it. So feel free to rewatch it. And we also have live streamed this across the country, so I know a lot of people are remotely watching this session today. And so it'll be up there next week. One closing comment on the AMAC Foundation. How many of you are AMAC members or are familiar with AMAC? Okay, great, great. The AMAC Foundation, of course, is AMAC's nonprofit, 501c3 nonprofit. And I want to call your attention to the service that we provide called Social Security Advisory Service. It's really our flagship program at the foundation. We have 6 trained and accredited advisors. So if you know anybody that has any questions about Social Security, feel free to contact us. Again, instructions for how to get in touch with that service are on the website, amacfoundation.org. And we know that anyone that having Social Security problems or Social Security questions faces a lot of difficulty getting a credible answer, even getting attention, frankly, sometimes. But we have 7 trained and accredited advisors, and there's no charge for anything that we do. So it's something that our founder felt very strong about, making sure that people could get the information they need when they need it. So please pass that around to people that you know that may have questions about Social Security. Just contact us. We're there to serve. So with that, I will thank you all for attending. Appreciate you being here. And keep an eye on our website also. There's an events page on there. When we schedule events like this, they're always posted on the foundation on the events page. And we just have a couple up there right now, but we're getting ready to develop a calendar for the late spring and summer months. So keep an eye on the foundation events page, and you'll see when other sessions like this are coming up. So with that, thank you all for being here. Appreciate it.